Hey, what's up, everybody? It's Stephen A. Williams, president and founder of thecreditrepairshop.com. I got some very good news. My office is almost finished. I'm going to be showing it off. Got my two screens here, got my big screen uh, computer here, my camera, got my books and like all of my books. When I look through all of my books that I have, this is thousands of dollars worth of education. That's what I consider. Books are like your extended education. And while I was putting my books in my bookshelf, uh, and I'm going to get some stuff behind me too. I'm going to get all of my certifications placed behind me. I think that that'll be better representation of of me for what I do for you and the business and my certifications for credit and debt and helping people. Um, One of my books that I got from a while back, this is like 10 years ago. And it's crazy how you can always reference back to things and how the universe will validate if you're doing something, and sometimes you need more validation or you're trying to seek out more ways to be able to help people. uh, you can pull a book off your shelf and open up the page and it'll be right on the page to give you an answer on something. And what I want to do is, this is a validation of what a lot of people kind of talk about, but they don't really know on these YouTube channels what they're really trying to attempt to do. They just go with the denial. And what we're talking about today is we're talking about lawsuits from third party debt collectors. We have had an explosion. I'm talking about, I would say, 10 to 20 people per day contact us for help with this. They either have a debt collector calling them, preparing for lawsuit, or they're in full blown lawsuit, or they've lost the lawsuit and now they're being sued. So it's like three stages of where people are contacting us, and very emotional, don't know what to do. They've even reached out to attorneys in their area. The solution when they reach out to those attorneys, file bankruptcy. And so what I want to do is I want to pick one little nugget for you, because I know you want to watch some other videos, or you're busy in the day, but I want to, and I appreciate you watching my video, but I want to give you a little nugget on something uh, that validated the work that we do here at the Credit Repair Shop with helping people with court summons. Because when you have a debt collector trying to sue you and you receive that court summons, there's certain things, if you pick it apart, because they're going to put together their whole plan to make it look like, Judge, this is everything. We got it all laid out for you. All you have to do is sign off on it and get us the money, so get us the judgment, so we can start garnishing the wages of this individual, or going into their bank account and taking the money directly from them. So when you watch other YouTube videos and they say, don't you don't have a contract with the individual, and that the way that, on the flip side, the debt collectors who buy debt, what they try to use is the terminology of assume, assigned, but what they're actually buying the debt. But they throw those words in there, and let me tell you the reason why they throw those words in is because they're trying to get past a legal definition. The legal definition that they're trying to get past is, in an affirmative defense, you can actually assert something that a lot of debt collectors don't want you to know about. And some judges will not allow that lawsuit to go through. And some debt collection attorneys will not want to proceed because if they know the judge that they're at, or maybe they're not familiar with the judge that they're dealing with for your case, or the uh, debt collection lawyer that they hired in their area tells them that, hey, we're not secure with moving forward with this, because this is what that collection lawyer is going to be up against. In an affirmative defense, you can have what's called a statute of frauds. And the statute of frauds is basically where they don't have any documentation showing that you specifically signed for the claimed amount that they're claiming that you owe. Now, I know that it's kind of like of a gray area because you're probably thinking, and what everybody is thinking is that they're they're buying a debt and they're bringing it over to you, saying that you owe this debt to us because we bought it from that original creditor. And surprisingly, a lot of judges will allow that to just be a pass through unless you bring up that in your affirmative defense. So, if you've been watching my videos in the affirmative defense, the things that we like to challenge is the privacy, documentation showing that you allowed them to view your private information, regardless of it being passed over from one company to another company, because we know that privacy is a huge issue in the business world right now. So show me how you got access to my private information, regardless of you buying the debt. Show me from that original creditor how this is being transferred. See, the reason why they're allowed to get it transferred now is because people don't challenge it. The next thing is the amount claimed. They always, you probably been wondering, why do they have this amount in there? Like, if I owe this amount, why do they go through all of this trouble to prove that I owe this amount? And then when you break down how they prove that you owe the amount, it doesn't add up to be, with the documentation that they provide, does not add up to be the amount that they're claiming. So they may say you owe $5,000. They put two statements on there, two of your old statements, and if you added up the charges on those statements, it might be like a couple of $100, or it might be $500, but it's not $5,000. So you have a right to get that information to add up to the $5,000 claim. Here is a big something, here's something that you may not know, is that they will not be able to get that documentation to add up to all of the charges, payments, interest rate charges, credits, everything, to prove that $5,000 claim. They won't be able to get that information. You should use that in your affirmative defense. Also, a complete account number. They never have the complete account number. Have you ever wondered why, when they buy the debt from an original creditor, why they don't supply them with the complete account numbers? It's because they are not allowed to show them that complete account number, and that's an internal number, account number for the original creditor. So if it was your account number, they bought the debt from the original creditor, why aren't they allowed to pass that over to the third party debt collector? Why does it have to be redacted? It has to be redacted because they did not fully go through the privacy disclosure, having your signature signed saying that they can share all of your private information. So you can see how this is all connected. And this is why a lot of the third party debt collectors don't like to go to court and have all of this information displayed to the judge or to a jury, because they're going to lose, because it's going to make their case incomplete. Now, the next part with the statute of fraud is that, and this is reading straight from the law book, the agreement alleged in the complaint was not a written or signed, was not in writing or signed by the defendant or any person authorized to act as a defendant. So what they're doing, this is how they try to, like, formulate this and put their documentation together to overcome this, is that they'll put an affidavit of sale. The affidavit of sale will be from the president or whoever is the representative from the original creditor. But you'll notice that in that affidavit of sale, it never has your name specifically, never has your account number specifically, and never has your balance amount specifically. Also, in that in that affidavit from the original creditor, if you read through it carefully, usually on the last paragraph, is that it doesn't even have, it says that the debt collector who purchases the debt, everything that they got is what they're going to get, and they assume all responsibility for any errors or omissions or whatever is that could be found that is wrong. So if they go and they try to sue someone that had filed bankruptcy that is in that portfolio that was sold. The third party debt collector cannot go back to the original creditor and say, hey, you sold us this that had someone that was in bankruptcy and you should be responsible because now we're getting sued. They can't do that. They have to assume 100% of the responsibility for taking on that whole debt portfolio. So why would, if you think about it with that understanding, with that understanding, why wouldn't you just attack fully everything that they have? Like, stop trying to avoid. How about just going straight at it? Everyone else tries to have you avoid, and it specifically states here in this law book that if you just state that not enough information to admit or deny, or that you straight flat out deny the information received from the third party debt collector, that is not going to be enough. That the judge will say that that is not enough if you don't have an answer to that or an affirmative defense for that denial. You can't just deny your way out of it because they're going to say, well, according to this case with the Supreme Court, we're allowed to buy debt and we're allowed to collect on the amount of face value, not just on the small pennies on the dollar amount that we bought. We can actually say that this is a claimed amount if the debtor if the debtor does not challenge the claim. So if that's why there's so many default judgments, that's why people lose in court when they just show up and say, I don't know, or I didn't have a contract with them. They did not go the extra mile, which is what it's going to take to have the judge be able to say, okay, what about this information that they're asking for? What about the contract? Does it meet an affirmative defense statute of fraud by you providing information to the court without this individual's signature or any authorized party's signature on the debt that you have? Where does show the contract between you and them? And this is something that we always ask third party debt collectors to provide, and they don't have that information. So they're going to go with what they have, and then you have what you have to challenge it, and then the judge is going to make the decision. And you'll notice that they always say that they don't want a jury by trial. The reason why is because they know if you were to go up there and you would just submit your information, just say that you had your affirmative defense and you just said, well, show me the documentation where you can have access to my private information. We don't have that. Show me the information that proves the $5,000 claim. Just give me all of the charges. If you assume all responsibility as you stated in your summons complaint and in your affidavit exhibit that you supplied from the original creditor, that you assume everything. That means that you need to provide me everything so I can make an educated decision on if this amount is even correct. This was an account that went bad. I never did business with you, and you didn't show me anything that showed my signature that I did business with you. But if you're claiming that you assumed the debt or you bought the debt, show me everything, because if I was to buy the debt or buy something from someone, I would have to come to them with more documents than just a couple of statements. So you can see how this is turning everything around, and it can make the judge see it a different way. And it definitely, if you have a jury of your peers, make them really see this a different way. Now, there's some other things that I won't go into right now, but I'll go into in some other videos where you would be able to even amp up your response, and would probably outright make the debt collector just say we're going to dismiss. Now, what we've been seeing from the third party debt collectors is that they've been using a tactic of delay, delay, delay. I've seen it to where they delayed it out 1 year. And the reason why they're trying to delay it out for 1 year is because they're hoping that you'll just forget about it. You won't come to court, and then they'll get a default judgment. They're also, just flat out saying that they want to uh, question all of, like, why are you asking all this information? So what they'll do is they'll amp up and they'll send you a document saying that we want you to pinpoint every thing that you had in your response to us so they could try to break apart what your case would be against them. And then they'll make a determination if they're going to move forward. And all that is just reiterating the information off of what they gave you. See, what they don't expect you to do, what they don't expect you to do is they don't expect you to tear apart the information that they have. Remember, if you're the defendant, you don't give them information to have them be able to win against you. That's what they've done. That's the setup that they've done with people who didn't know their rights. But now that you know your rights, because I'm letting you know, and other people have probably let you know, is that you set up that affirmative defense basing it off, challenging the documentation that they're giving to you. So you're actually tearing apart their case against them. Like, you don't, if you do this the right way, you will be able to, like, probably get most debt collectors to just back down and not come after you, because they're going to say, we can't overcome this information. These are good questions that this individual is asking us to bring documents. And if we purchase the debt from the original creditor and we assume everything, it's a logical question that the judge would say, well, where is the rest of those documents? So they're using the delay tactic. They're using the amp up tactic where they'll try to scare you and say, you need to fill out this longer form of a summons response, which is to prepare for a trial, which doesn't always mean that they're going to go to trial. It just means that they're trying to amp it up to see if you would even respond to that. And if you respond to it with your asking the same thing, they're just breaking it down, it will make most debt collectors say, well, we think that we're going to go ahead and just ask for another delay, hoping that you won't come to court. And so I wanted to get this video out because there are a lot of people who are being sued. Like right now, what's going to be happening with the way that credit card debt is and with the way that the economy is for some people, this has been amped up, and I want to be able to make sure that you have some sort of way to be able to help yourself fight back against third-party debt collection lawsuits. If you need help with a third-party debt collection lawsuit, I have a link below this video showing you how to prepare your response to a court summons, and or if you would like us to prepare it for you, we can assist you with that. Links are below this video. If you have third-party debt collectors coming after you early, I invite you to get my 3-pack of letters. It's below this video. Please make a donation. It helps support the channel and my time providing this information. It's very good information. It can literally save you hundreds, if not thousands of dollars, time, frustration, everything, if you can stop them early. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes a difference, so you can see my 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com so you can grab your TransUnion, Equifax, Experian credit reports and all 3 scores. Thank you for your time. Please subscribe to the channel, post your questions and comments, and please like this video.